Are you recording? All right. Good morning. It is 8:54 a.m. on July 24th, 2025. These are the status conferences of the Oil Conservation Division. It is the second regular docket of the month. My name is Gregory Chikalian. I'm the hearing examiner. We do not have a technical examiner today because these are status conferences that don't require a review. We are conducting a special docket on Tuesday, the 29th of July, which we now have the potential of one contested hearing. All the other contested hearings have turned into hearings by affidavit. I can't always promise that the hearings by affidavit will be conducted on the day that we schedule special dockets. In the pre-hearing orders, we do put that if the case is resolved, it may go to the next regular hearing by affidavit. But since we have so many of them, we thought, why move them all to August 7 when we already have a technical examiner? So that being said, let's call the first group of cases. This is Rockwood Energy. This is number 1 through 6 on our docket: 25241, 42, 43, 44, 45, and 46. Entries, please.
Good morning, Mr. Hearing Examiner. Caitlin Luck, appearing for the applicant in this case, Rockwood Energy LP.
Thank you.
Good morning, Mr. Examiner. Dina Bennett, appearing in these cases on behalf of Coterra.
Thank you. I believe that's all the parties, right, Ms. Luck?
That's correct.
Ms. Bennett, I'm going to start with you. You've entered an objection. What's happening with the objection?
Thank you. So Coterra did enter an objection to all of these cases because Coterra intends to develop the acreage. And as I've mentioned at prior hearings and status conferences, there's been some confusion between with Coterra about who is actually going to be the opposing party in these cases. The Rockwood cases were filed back in February 26th, and they requested an April 10th hearing. And then, as you may recall, Coterra objected at the beginning of April, and then they were set for a status conference on April 24th. Well, in between our objection and the status conference, the prior council withdrew, and Ms. Luck entered her appearance the day before the status conference. And at that time, as I explained in prior status conferences, Coterra was under the impression that Rockwood was negotiating with Mewburn. And so there was a little uncertainty about who the opposing party was. And then right before our next status conference, Coterra learned that Mewburn had not entered into a deal with Rockwood. Well, now on June 15th, Rockwood's landman emailed Coterra's landman and said that they had entered into a deal with Mewburn for at least 2 of the cases that are on the docket, and that Mewburn was going to be sending out proposals for those cases, different proposals. At least that's what was the implication. So Coterra has been trying to figure out who to negotiate with, and has been trying to negotiate with both Rockwood and Mewburn. In July, Coterra did send out competing proposals. They weren't sent out in time to make the August 12th docket, which is when we have a contested hearing. So at this point, I think there's 2 options. One, we can go forward with the contested hearing on August 12th, which will be, in my opinion, a waste of the division's time and a waste of the party's time, because it appears that at least for 2 of the cases, Mewburn is going to be sending out its own proposals. Or we could try to reach an agreement about a different contested hearing date. And Coterra did reach out to Rockwood yesterday and proposed a schedule that's only a month delay, where Rockwood would either dismiss its cases, because I know the division doesn't really condone continuances of contested hearings. If the division were to consider that in this case, that would be also helpful. But the proposal that Coterra sent was that Rockwood would dismiss its applications, and then Coterra, Rockwood, and Mewburn, to the extent Mewburn's going to submit applications, would file applications for the September 11th docket. And Coterra is willing to agree to the very first available contested hearing date in September. So that's a month delay maximum, maybe 6 weeks actually maximum. And that gives Coterra and Rockwood and Mewburn a chance to get the actual applications before the division. The division will have the actual parties to the contested hearings before it. And it also allows the parties a month to hopefully resolve this. In fact, yesterday, Coterra, as I mentioned, emailed Rockwood, and this morning I tried to broker a four-way call between all four parties, the two attorneys and Rockwood and Coterra, to see if there isn't a way we can just all get on a call and work this out. And Rockwood is willing to have a call, but not today. Maybe tomorrow, maybe next week. Rockwood isn't willing to change the August 12th hearing date, even though, I have an email from their landman saying that Mewburn is going to be sending out proposals for some of this same acreage. I understand that Rockwood wants to move forward with August 12th, but there also has to be some flexibility to allow for the uncertainty that is present in these cases and to allow the division to have the actual parties in front of it.
Thank you.
Thank you.
Ms. Lynn?
Well, I think that what we're dealing with here is the fact that these cases have been pending for 5 months. They were filed quite some time before I entered an appearance. And as Ms. Bennett indicated, Coterra has known that Mewburn may be involved or may not be involved the entire time that the cases have been pending, because Rockwood has not drilled wells in New Mexico previously. And it's actually, in our opinion, advantageous for there to possibly be a deal where Mewburn is involved. So at this point, Rockwood wants to go to hearing on August 12th and present all of the cases to the division and have the division decide whether or not pulling orders are appropriate at this point in time. I have the pre-hearing order here that was issued by the division on May 22nd. And at that point in time, Coterra could have filed applications to compete with the filed Rockwood applications. And once again, that was back in May, and then 2 more months have passed and no applications have been filed. These are basically the only 2 interest owners out there. Now that Mewburn's involved, there's another working interest owner, but it's a very simple situation to send out well proposals and file applications within a 5-month time frame, and that hasn't happened. And so based on the fact that we have a pre-hearing order issued by the division on May 22nd, Rockwood's ready to proceed to hearing on August 12th. All of the arguments that Ms. Bennett's making with regards to operatorship, those are all things that can be brought up at the contested hearing on August 12th for the division to hear and consider. I've been in her shoes before without competing applications, and those cases went to hearing at that point in time. The division didn't grant continuances or move the applications from the contested hearing schedule where it was set under a pre-hearing order like we have here. So at this point in time, Rockwood's ready to proceed. And like Ms. Bennett indicated, Rockwood didn't want to have a last minute call this morning to push out this hearing any further. We've had this hearing date set for a while. We're ready to go to hearing. And Rockwood is willing to continue voluntary negotiations in good faith with Coterra before the hearing date, as we understand our obligation. However, Rockwood didn't see that was appropriate before the hearing got started.
So Ms. Luck, Ms. Bennett mentioned a couple things that I'm not sure you addressed, so I'd like to hear your perspective on. First of all, she raised the issue that her client wanted to negotiate with someone, but they weren't sure who to negotiate with, whether it be Rockwood or Mewburn or someone. In your mind. Do you know about that?
Yes, and I know that Rockwood has made lots of efforts to negotiate with Coterra since these applications were filed, and before, by sending the well proposal letters to Coterra, starting with good faith negotiations before these pooling applications were even filed in February. And so Rockwood has made multiple attempts to have conversations with Coterra. Mewburn has also conversed with Coterra. There have been conversations that happened before the offer that she's discussing this morning.
And you know that for a fact?
Yes, sir.
Okay. And then the next issue that Ms. Bennett brought up was that I guess Rockwood made a deal with Mewburn, and Mewburn is potentially filing competing applications or some sort of application as well?
And so there is a deal between Mewburn and Rockwood, but Rockwood remains a working interest owner in the unit with the right to drill thereon and can proceed with its pulling applications as filed regardless of the agreement with Mewburn at this point in time with respect to those 2 units. And so Rockwood would like to proceed with its applications on those 2 units. And if at any point in time Mewburn continues the operations of those units, that would be disclosed. And of course, Coterra would know about that.
Has Rockwood received Coterra's proposal letters?
Rockwood has received Coterra's well proposal letters, yes, but no applications were filed.
Right. I'm just asking if your client has received the well proposal letters that Ms. Bennett mentioned were sent out.
Yes.
Okay. Do you know when they were received, or Ms. Bennett, do you know when they were sent?
They were sent on July 10th.
July 10th. Okay. And is it for, and I don't know anything about these competing the proposal letters, but does it overlap the exact, is it the same acreage?
No, it's not the same acreage. In 2 cases, well, in all 6 cases, Coterra is proposing a larger spacing unit than Rockwood is. So Coterra's completely overlap Rockwood's spacing units, but Rockwood's do not completely overlap with Coterra's. And Coterra is the majority interest holder in its units. And I do, just if I could briefly address something that Ms. Luck said.
In
Yes,
just a
certainly.
moment, I'd like to get to that point.
Mhm.
So Ms. Luck, something that Ms. Bennett just said, which was Coterra is the majority interest owner in its unit, and it sounds like its unit encompasses all of Rockwood's. What is the ownership of Rockwood in its proposed area?
And I believe that we reviewed this at one of the earlier status conferences. It's approximate, like in each unit, it differs slightly, but in some units, it's like 35-65, one unit's 45-55. The split is very close amongst the interest owners as between Rockwood and Coterra in all of these units. And I do have the ownership interest breakdown. I can pull it up and call it
Okay,
out
why
for
don't
the
you pull
division.
it up while I hear this follow-up?
Thank you. So the interest ownership that Ms. Luck will be sharing, I believe, predates the deal with Mewburn. So if in fact Mewburn and Rockwood did enter into a deal, Rockwood's ownership interest would be lower, even if they did retain a working interest. So just want to make that point before we go too far down that road. But
Are you saying that they negotiated away some of their
yes, they would have had to.
in the unit?
That's what I mean. I don't know anything about their deal, but if Mewburn was going to send out well proposals, it needed to have acquired a working interest in the unit. But I do have an email here from Kelton Powell dated June 16th, 2025 to Coterra, where Mr. Powell writes Shepherd, which are two or four of the cases, I can't remember. We signed a deal with MOC on this acreage Friday, and they will be sending you guys proposals here shortly. So the implication from that is that Coterra should be expecting proposal letters from Mewburn. Not that Coterra needs to, there's been no like bad faith negotiations on Coterra's part. It's been a moving target. Even as of June 16th, Coterra was now under the impression that they should be expecting proposal letters from Mewburn, from Rockwood's own landman. This isn't a situation where Coterra has been just sitting on its hands idly waiting to see what happens. There's been a moving target about who's sending out proposal letters. You know, in June, it was going to be Mewburn for the Shepherd wells. In June, Kelton Powell mentioned a trade deal with Coterra. I've asked Coterra to provide me with dates that they tried to call Rockwood back to talk about the trade deal. This isn't a situation where, you know, the parties are at a standstill. This is a situation where discussions have been kind of a moving target, but now we seem to have things worked out. Mewburn has acquired its interest in Shepherd, Rockwood and Coterra, and potentially Mewburn, if they're going to be the operator of George Mitchell, can now have discussions. The playing field has sort of been cleared up at this point. So that's why it feels premature to have a hearing on August 12th.
Have you received Mewborn's proposal letters?
No,
So it's been more than a month since you got that email, and you haven't received anything.
no.
Okay.
But I do know that Coterra has been in discussions with Mewburn about this acreage and has been in discussions about joining a JOA, talking about the competing development plans, who's going to operate. So Coterra has been in discussions with Mewburn about the Shepherd acreage.
Ms. Love?
Well, and I think that what Ms. Bennett is presenting to the division, these are all arguments that should be made at the contested hearing.
Okay.
She needs to show up with her witnesses and cross-examine Rockwood's witnesses that are presented at the hearing for the division to consider whether or not pulling orders should be issued to Rockwood under these circumstances. These are all arguments for the contested hearing, and I think that that's why we're here today for a status conference to say, yes, we're still intending to proceed to the August 12th hearing as set by this pre-hearing order. Rockwood has lease expirations in these units, and there's a reason why these applications were filed in February to proceed to hearing within short order as expected under the division's docketing. And so I think at this point in time, there's been a lot of back and forth between Rockwood, Coterra, Mewburn, all as detailed by Coterra's counsel just now. Coterra has been in contact with both Mewburn and Rockwood and understands the trades and the negotiations that happen on the ground in oil and gas deals. And a delay of the hearing is not going to change that fact. The parties could have worked out a deal previously.
Did you find the interest that you
Yeah.
were looking at?
Yes.
Okay, what is it? And by the way, did your client negotiate away a certain amount of interest to Mewborn?
Correct. So now the numbers that I'll be calling out will be a working interest that's now owned in some percentage by both Rockwood and Mewburn.
But are Mewborn and Rockwood aligned?
They are not related companies, but they are correct aligned in the sense that, yes, they.
Who's representing Mewborn? Is anyone representing Mewborn here?
Well, Mewburn is not a party in this case.
They're not, okay.
Yeah.
But I mean, they have an interest in these cases, right?
Yes, they will have an interest in these cases. Collectively, all of them. They do have an interest in a portion of them at this point in time.
So, and when was this negotiation finalized with Mewborn?
And I think it was mid-June. That's what Ms. Bennett
Okay.
had discussed and that's only with respect to a portion of the cases. It's not all of the
I
cases.
understand, but they've not entered an appearance in these cases that I know of, and you don't know of it either, and you don't know of it either. Okay, so here's what, I mean, I've heard a lot of back and forth about what's going on here. When would your competing applications be ready to file?
I can file them today.
Okay, you can file them today. Okay. And of course, we have to give 20 days notice once they're filed before we have the hearing. In the past, what we've done in a situation like this, and Ms. Luck was involved in a case such as this, is we began the hearing and then we continued the hearing to perfect notice so that we could hear all the cases at the same time. These are old cases. If these were not February cases, I would lean more toward your solution, which is let's just kick it down to September. But in a way, that's what we will do. In a way, we will continue the hearing to 20 days after today, whenever that may be. We'll figure it out in a bit to cure notice. But, you know, to be consistent, I have always leaned toward the applicant. Your client has known about these. I realize that there's a moving target for you, but their client has known, and I'm sure they're sophisticated enough to understand how all this works. But I lean toward the applicant to move things along, or dismiss the cases, and we're not doing that, obviously. So we'll keep this on track for August 12. Ms. Bennett, if you file your applications today, when is the 20 days that we could do a special notice? When is that?
That would be August 13th.
Oh, the next day.
Mhm.
Oh, well, then that makes that easy, doesn't it?
If I thought that you need, okay, so the division only needs 20 days
We only need
to
20.
to notice.
That I know of.
Mhm.
Does someone want to tell me?
Well,
differently?
there is the requirement that we file the application 30 days under the rule, 30 days before the hearing date, even though the division only has to give 20 days notice. So I guess I was assuming it was 30 days for me to follow the rule, 20 days for you all to follow the rule. But yeah, I just did some quick math. Today's the 24th. If we need 20 days, that's August 13th-ish.
That works. Is there anyone who has an opinion that that can't be done?
Mr.
I'm
Hearing
not
Examiner?
hearing anyone volunteer anything. Yes.
So technically I would be out of compliance with the rules if I did that, because the rule does require an applicant to file their application 30 days before the
Is
hearing.
there an objection, Ms. Luck?
I don't object if it holds our August 12th hearing date.
Right.
The other option would be there is a contested hearing set for August 26th. And that would allow me to comply with the rule and still allow for 20 days.
Hold on a second. Ms. Bennett, you've been doing this a long time. Is there a reason why the rule says that you need to file an application 30 days before the hearing, and yet we only need to provide 20 days notice?
I don't know the answer to that. I do know that Mr. Bruce said at a hearing, and Mr. Bruce has been doing this longer than I have, that the rule used to say that the application had to be filed 20 days before a hearing. And then at some point, the rule was changed to require 30 days.
Okay, well, that doesn't, okay, that doesn't mean, so far, I've not heard anything that changes my mind about why we would require you to file 30 days in advance, and yet we have to notice 20 days. I mean, maybe it gives the division 10 days to put the notice together. I don't know. But that being said, unless I hear an argument that it's not going to work, Frey, are you able to do a special notice for the 13th?
I can if I get the applications sometime early enough today that I can still prepare the notice and get it sent out today.
Okay. Ms. Bennett?
I will file as soon as I get back to the office.
Perfect. So it sounds like everyone's going to get what they want. We'll get a contested hearing. Your client will hear their competing cases. Ms. Luck will get to move forward with her cases. Is there anything else?
Nothing further. Thank you.
Okay,
Thank you.
thank you.
And I just want to confirm this starts at 1 or 1:30 on the 12th,
Even better.
the afternoon. That's right.
We know we're going to go into the 13th, so it's even better.
It's
So
fun.
you'll present your case on the 12th. If you finish your case, we'll end for the day there, and then Ms. Bennett can present her case on the 13th, starting at 9 a.m.
Thank you.
Thank you. Ms. Bennett, your witnesses are available?
Yes.
Good.
They may be appearing virtually given the limitations on timing, but they will be
You know that's
available. Yes.
okay. We're off the record in those cases. Thank you. Calling Pride Energy. This is case number 7-25455. Entries, please.
Sharon Shaheen on behalf of Pride Energy.
Thank you.
Michael Felderword, Santa Fe Office of Holloman Hart on behalf of EOG Resources, and I believe it's a you call 25455, that would be the EOG case. And that is combined with 25312.
Thank you. Let me also call 25312. Thank you.
And Mr. Examiner, Dana Hardy with Hardy McLean on behalf of 3R Operating and Red River Energy Partners, these
Thank you.
cases.
Mr. Bruce?
Mr. Examiner, Jim Bruce, representing Kaiser Francis Oil Company.
Okay, thank you.
Good morning, Mr. Examiner. Carrie Hatley, representing COG Operating and ConocoPhillips Company.
Thank you, Ms. Sally. Okay, Ms. Shaheen, it's your case. Who has entered an objection in your case?
I know that EOG has entered an objection. I believe all the parties entered objections. But the good news is that Pride and EOG have been conferring in good faith. They have reached an agreement in principle. They're in the process of negotiating the final details and papering that agreement up. So we would ask that the contested hearing set on August 12th be vacated and continue to a status conference if necessary on August 21st.
Are you saying that your negotiations with Pride and, I don't know, did you say COG?
EOG.
EOG, thank you. You said that there were other objecting parties.
That is correct. Objecting to Pride's application, and actually, I don't know whether they objected to EOG's application, but if Pride papers up its agreement with EOG, Pride will be dismissing its applications.
So we wouldn't have a contested hearing, you're saying?
That is correct.
Okay, Ms. Hardy?
And Mr. Examiner, at this point, 3R and Red River are monitoring these cases, although it's possible that 3R could end up objecting, but they haven't yet. But they weren't aware of this turn of events with Pride and EOG, so I would need to consult with my client about their position.
Mr. Felderberg?
Mr. Examiner, so EOG does have a competing pooling case.
Right.
That's why we have a contested hearing. They overlap in the west half of section 29. The parties who have objected to Pride's case, my understanding, they support EOG's more extensive development. I know that the parties were in discussions, and I knew that they were having very fruitful discussions. I'll take this Shakeen's word that they've reached a agreement in principle. I know that they're looking at things very closely. We don't disagree that it would make sense to go ahead and vacate this hearing since the parties are so close to an agreement. And that agreement would seem to accommodate or will accommodate the interests of a vast majority of the working interests, not only in these sections, but also in the west half of section 29. So I'm glad that they were able to reach an agreement because I couldn't figure out why we were going to have to go to hearing. So I do think we can help you with your docket on August 12th by having that hearing vacated and setting it for status conference. And I would expect, so based on Machine's representation, that the parties will have an agreement and they will be dismissing their case and we'll be able to proceed with our pooling case by affidavit.
Ms. Hatley?
I have no objection to vacating the August 12th hearing.
Mr. Bruce?
No objection.
If it's helpful, Mr. Examiner, I note that these cases were initially on the May docket, so it hasn't been very long that they've been pending.
Okay. Well, from what I understand from you and Mr. Felderwert, the parties have an agreement in principle that they need to reduce to a writing. And once that's done, you're going to dismiss your case.
That is correct.
And thereby, EOG will present its case by affidavit. It wouldn't be on the August 12 docket.
That would be fine.
It would be in the September, whatever the first September docket is. I think that's what the pre-hearing order said anyway.
Right.
So I agree that the hearing should be vacated and that the cases should be continued by the parties to the second docket in August for a status conference.
Let me just for the record, I don't know if EOG has agreed to what Pride has proposed. I know that they are looking at it and that it looks favorable, but I don't think they've actually said we agree.
I see.
But I agree that it's close enough and the facts of this case make sense that this matter shouldn't have to go to hearing.
Thank you. Anything further, Machine?
Not for me. Thank you.
We're off the record in those two cases.
Thank you.
Let's call the next two cases, 25321, 25322, 3R operating, excuse me. But then there's two other cases by 3R, but I don't think they're joined, so we'll call them separately.
Thank you, Mr. Examiner. Dana Hardy with Hardy McLean on behalf of 3R Operating.
Good morning, Mr. Examiner. Dina Bennett on behalf of Cimarex Energy Company of Colorado.
Gabrielle Gerhold on behalf of Civitas Permian Operating.
Welcome. You want to enter an appearance?
Yes, I would enter my appearance this time in both cases.
Okay, and you'll file a substitution of counsel?
Yes, sir.
Thank you. Are you also going to enter an appearance on the next two cases as well?
Yes,
You
sir.
are, okay. All right. Ms. Hardy, these are your cases. How do you want to proceed?
Mr. Examiner, these cases are set for a contested hearing currently on August 26th, and the parties are negotiating and making significant progress. So I am cautiously optimistic that a contested hearing may not be necessary, but I don't know yet.
Okay. Is that all you wanted to say?
At this point, I would request that we keep the
Right.
August 26th contested hearing date, and then we can vacate it or present by affidavit once we have a final determination.
And Ms. Bennett, are you objecting?
Yes,
Okay.
I filed an objection on April 17th. And Cimarex agrees with Ms. Hardy that negotiations are progressing well, but that it also makes sense to keep the August 26th docket date for now, and hopefully we'll be before the division before then to vacate that hearing.
Okay.
In the meantime, though, Cimarex did file competing applications, which are not identified on the pre-hearing order. And so I'll file a joint motion to amend the pre-hearing order to add the Cimarex cases.
And do those appear on the first docket in August? Is that?
They did, but 3R objected, and so Freya moved them.
To the 24th?
I don't know if she moved them to the 24th or if they're just pending being moved to the 26th, but either way, I'll work that out with Ms. Chance.
You happen to know the case numbers?
I do. Their case numbers 25506 and 25507.
And it's, are you saying it's Civitas or are you saying it's
It's Cimarex.
Coterra?
It's a subsidiary of Coterra. It's Cimarex Energy Company of Colorado. Mhm.
Cimarex, Coterra. Okay, thank you.
Thank
So
you.
you'll file a motion, we'll amend the pre-hearing order, we'll stay with August 26th for now, and the parties will negotiate.
Yes, thank you.
Ms. Gerholz, anything?
Mr. Hearing Officer, just say on behalf of Civitas Permian Operating that we have also sent competing proposals and are attempting to work through agreements. I believe there will be a path to resolution and we would have no objection to the current calendaring.
Perfect, thank you. Anything further, Ms. Hardy?
No, thank you.
Okay, we're off the record in these two cases. Let's call your next two cases, 25323, 25324. Entries, please.
Dana Hardy with Hardy McLean on behalf of 3R Operating.
Sharon Shaheen, Spencer Fain, on behalf of Flat Creek Resources.
Thank you.
We are not objecting, we are simply monitoring.
Thank you.
And Gabrielle Gerholt on behalf of Civitas Permian Operating.
And did you object?
I believe we are monitoring these. I will contact opposing counsel. I do greatly apologize. Our personnel changes are not other companies' problems. However, I have very limited information on this.
I understand. Ms. Hardy, who's objecting?
Civitas did object, actually, in these cases.
We continue our objection.
Right? Are these set for a hearing?
These are like the prior cases set for a contested hearing on August 26th. And I think we're basically in the same situation in these cases, except with respect to Civitas. So there are ongoing negotiations and cautiously optimistic that they'll be resolved. But at this point, we'd like to keep the hearing date.
Perfect. Do you know, Ms. Garros, are there any plans to file anything that competes, or will you just come to the hearing and object?
I believe we will have a resolution before then, and I do not anticipate any competing application.
All right, thank you. Okay, anything further, Ms. Hardy?
No, thank you.
All right, we'll keep these on the docket. Thank you very much. All right, moving on to numbers 13 through, well, I think the end of our docket, 13 through 17. These are tumbler operating cases, 25462, 63, 64, 65, and 66.
Sharon Shaheen, Spencer Fain, on behalf of the applicant, Tumbler Operating.
Dana Hardy with Hardy McLean on behalf of Marathon Oil Permian.
Mr. Examiner, Matthias Sayre with Bradford Sayre on behalf of EOG Resources.
Thank you. Okay, I think that's all the parties. Ms. Shaheen?
Thank you, Mr. Examiner. These applications were filed on June 11th for hearing on July 10th. Both Marathon and EOG filed objections. I understand that Marathon has sent out well proposals and that they should be momentarily filing applications. Tumbler would like to have this set for a contested hearing as soon as possible.
Okay. Thank you. And you said something about filed on one day and set to hear on a day before? You said 11th and 10th?
June 11th and July 10th.
There we go. Thank you. Miss Hardy?
Mr. Examiner, Ms. Shaheen is correct. Marathon has sent out competing proposals, and we will be filing competing applications. And those should be set on the September 11th docket based on the filing timing. And we would also request a contested hearing, and any time after our applications are ripe on September 11th is fine with Marathon. Late September, second half of September is fine.
We have 2 dates in September to offer. That would be the 12th and the 16th.
I think either one of those is fine with Marathon.
Machine?
Same for Tumblr, either one.
Well, I think it's your applications or your initial applications. Which date do you prefer?
I think I should just double check my calendar real quick.
Okay, take
If
a
you
minute
don't
while I
mind.
hear from Mr. Sayer, and then we can move on. Mr. Sayer?
Yeah, nothing to add. Those dates are workable.
Did you object, Mr. Sayer?
I believe the EOG did file competing proposals. But that's as much as I know right now.
Okay, I'm confused. When did you file them?
I don't have that information in front of me right now. I apologize. Information was late coming to me.
Ms. Shaheen, do you know, have you heard of the EOG competing applications?
The latest that I heard is that EOG is not going to be filing competing applications. That is as of yesterday. I understand that Tumblr has been conferring with EOG, and that was their understanding that EOG had decided, at least at this time, not to file competing application.
Thank you. Do we have another entry of appearance?
Good morning, Mr. Examiner. This is Jordan Kessler on behalf of EOG. Just to briefly summarize, I think the past couple of days, EOG will not be filing competing pooling applications in this case. I am unclear whether or not we objected, but at this point, we're simply monitoring.
Thank you.
Thank you.
And so you and Mr. Sayer are both representing EOG?
Following this statement, I'll be deferring to Mr. Sayer.
Okay,
Thanks.
So, Mr. Sayer, it doesn't look like you're filing competing applications.
That's good news.
Okay. Okay, so you're not objecting. Are you objecting still, or?
No, I do not believe so. I believe at this point we'll be monitoring.
Okay, very good. So, Ms. Hardy, this is between you and Ms. Shaheen, it looks like.
Looks like it. And I've conferred with Ms. Shaheen, and I think we both agree on the September 16th
Perfect.
hearing date.
We will, and I wonder, do we have the case numbers that we need to issue the consolidated pre-hearing order? I know we have Tumblr cases in front of me. Do we have your case numbers?
We do not,
Oh.
because they will be filed
Oh, okay.
shortly for the September 11th docket.
So you're saying by August 10th or so,
Yes.
you're going to be filing these. So we don't have the numbers
Correct.
yet. Okay. Will you file a motion when you do file yours so we can consolidate?
Yes, I will do that.
All right. We'll issue a pre-hearing order today, though, for September 16th. Anything else, Ms. Shaheen?
Not from Tumblr, thank you.
Ms. Hardy?
No, thank you.
Mr. Sayer?
No, thank you, sir.
Perfect. That concludes our business today. We're off the record. Thank you.